Landlord tenant law. Now, this is going to be a heavily tested part of the exam, and this is all going to be in the North Carolina specific section because landlord and tenant law is very different state to state. There is almost nothing in common state to state when it comes to landlord and tenant law. So nearly everything in this chapter is going to be specific to the state of North Carolina. Okay? So it means that all this is fair game for that state section. But obviously the landlord is the owner of real property who agrees to rent all of it or some of it to someone else who we call the tenant. Pretty straightforward definition of the two. Well, a lease is a contract. It's a contract that conveys an interest in this real property. Specifically, it conveys possession of the property, and usually it also conveys the right of exclusion. Remember that bundle of legal rights? We're talking about the right of possession and the right of exclusion. Well, the right of possession is the right to be there, and the right of exclusion is the right to do what? Tell other people not to be there. And usually when you're a tenant, you have both of those rights. You have the right to be there, and you also have the right to keep everybody else out. You don't have to just randomly allow people in there. We call the landlord the lessor and the tenant the lessee. The landlord is giving the lease, the tenant is receiving the lease. Okay, so lessor and lessee. There are lots of laws that protect tenants, and we got to know all of them. Okay? Now, I'm going to skip over, my slides got out of order here, so I'm going to fast forward if I can and get to the slide I need here. My computer won't cooperate. Well, maybe my slide's got deleted. Alright, you don't have a slide for this. So turn to page 236 in your book. I'm sorry my slide got deleted. I had some corruption in this file. I thought I had got to put back in there, but I don't. On page 236, we need to talk about the difference between a periodic tenancy and an estate for years. An estate for period to period and an estate for years. We need to talk about those differences. Okay? So you're going to be making your own notes here because you don't have a slide for this. Alright? So, a periodic tenancy is one that automatically renews. That's what you need to remember about it. A periodic tenancy automatically renews. An estate for years is the exact opposite. So what do you think it automatically does? Terminates. That is the key difference between the two. A period, I'm sorry?
I'm sorry, can you give us an example of each one?
I am going to give you an example of each one. In fact, I'm going to give you very detailed examples of each one. Most of you have lived one and not the other. How many of you have ever leased a residential property, an apartment, a house, or something like that? Okay. Somebody volunteer for me. On that lease you signed, it was a written, who had a written lease for an apartment or a home of some type? Think back to that lease. Does it have an expiration date on it? Yeah. Okay. All right. Does it have some language in there that says you have to give notice if you want to terminate the lease? Yeah? Does it further go on to say that if you don't give notice, it's going to automatically renew as a month-to-month lease? What kind of lease is that? That is a periodic tenancy. If it has language in there that says you need to give notice for this thing to end, I don't need to give notice for something that automatically ends, right? I need to give notice if I want to end something that does what? That automatically what? Renews. Periodic tenancies automatically renew. Most residential leases are periodic tenancies. Almost every residential lease you will ever see will be an automatically renewing lease. In other words, if you want it to end, one or the other party has to give notice. If neither one of you gives notice, what's that lease going to do? It's going to renew itself. It's going to roll over. That's an automatic renewal. Would you agree with that?
Yeah.
That's a periodic tenancy. Now, the estate for years, and don't let that phrase for years confuse you, because an estate for years can be for 2 days, or 2 weeks, or a month. It can be any definite period of time. If I needed to give notice for a periodic tenancy to end, what do you think I need to give notice for in an estate for years? To renew. Otherwise, if I don't say anything, what's going to happen to it? It's going to terminate. Does the landlord need to give me 30 days notice? No. Do I need to give the landlord 30 days notice? It is understood that that expiration date is the end. Amen. That is an estate for years. It automatically ends on its expiration date. Nobody needs to warn you. Nobody needs to tell you in advance. Nobody needs to give notice. That is almost never used in a residential lease. What kinds of leases are we left with? Commercial leases. Commercial leases are almost always estate for years. Now remember, it can be for any period of time, correct? Okay? We don't need to give notice for it to terminate. We would need to give notice if we wanted it to renew. So the language in a commercial lease would probably say something like, you must give 60 days notice if the tenant wishes to renew the lease. And the tenant may renew the lease at this rate for this many successive periods. But the notice part is if they want to do what? Renew. Whereas in the periodic tenancy, the notice was related to if they wanted to terminate or get out. These leases are structured to do one or the other automatically, and that's the only difference between them. The periodic tenancy is structured to automatically renew, and the estate for years is structured to automatically terminate or end. That help, Deborah?
Yes.
You good now?
Yes.
Okay. So the most common example of an estate for a periodic tenancy, or estate for period to period, would be a residential lease. That's the most common example. Now, a residential lease could conceivably be structured as an estate for years, but I've never seen one in all my... So the most common example is your standard residential lease for a periodic tenancy. The most common example of an estate for years is going to be pretty much any commercial lease. Pretty much any commercial lease is going to have a definite termination date that you don't need to give notice. My landlord on this building doesn't need to come to me and say, hey, by the way, your lease expires in March. It's up to me to monitor that and know it expired and give notice to them if I wish to renew that lease. Okay, does everybody follow that? All right, now, the other one you've got in your book, over on page 238, is an estate at sufferance. You have estates at will on page 237 and estates at sufferance on page 238. Estates at will and estates at sufferance. Now, here's a key thing to recognize with either one of these. No rent's being paid. An estate at will and estate at sufferance. The tenant is not paying rent. Here's why. Y'all remember way back when we started talking about the statute of frauds? How many of y'all remember that law? What does the statute of frauds say? Certain documents have to be in writing to be enforceable in a court of law. What documents did I say that we deal with a lot in this class must be in writing? Not leases. What documents did I say must be in writing? Sales contracts, right? Listing agreements must be in writing. What document did I say specifically doesn't necessarily have to be in writing in this state? A lease. Here's the problem with leases. Because we honor verbal leases in this state, we assume that if you're paying rent, you have a verbal lease at the very minimum. Does that make sense for you guys? That if somebody is paying rent and the landlord is accepting that rent, we're going to create a lease for you whether you have one or not. And much like tenancy in common is the default way to own property together, the periodic tenancy is the default lease that gets created for you. And specifically, what period to period do you think you're gonna get if you have a non-written lease in North Carolina?
Month to month.
Month to month. So if somebody pays you rent, you don't have an estate at will. You don't have an estate at sufferance. If they pay you rent, what do you have? A month-to-month periodic tenancy. Does that make sense for you guys? So now let's talk about what an estate at will is. An estate at will is permission to be there. You have my permission to be in that property. But you have my permission to be there without paying what? Rent. Because if you pay me rent, we most likely just created a periodic tenancy in this state. Because we recognize oral leases. Does everybody follow that? You have my permission to be there. Well, if an estate at will is my permission to be there without paying me rent, what do you think an estate at sufferance is? What do you think an estate at sufferance is? You don't have my permission to be there and you're not paying me rent. Now, that sounds an awful lot like a T word. What does it sound like? Trespassing. Here's the difference between an estate at sufferance and trespassing. Trespassers never had the legal right to be there. They were breaking the law when they came in. People who have estates at sufferance came in there legally. They now are there illegally. Who does that sound like to you? A tenant that has done what?
Squad. Not paid.
Done what?
Squad.
Stayed too long, right? A holdover tenant. Their lease has expired. They've been given notice that they no longer have a lease, and they still won't get out. That's an estate at sufferance. Now here's where you get dangerous. This is why you got to understand landlord and tenant law. If you're their landlord, and you gave them notice, let's assume it's residential we're talking about here, right? So we're talking about residential, we're talking about a periodic tenancy. Is everybody following me, right? They came in there, they had a periodic tenancy. Your lease said you got to give them 60 days notice, and you did. You gave them 60 days notice, you got to be out. Your lease expires on December 31st, so on October 15th, I told them they got to be out. Is that 60 days minimum notice? Sure. They got to be out. January 5th, they're still there. I go over to the house and they're still there. Are they now an estate at sufferance? Yes. They started with the legal right to be there, but they no longer have the legal right to be there. Y'all listening? You paying attention, right? What had you better not take from them? Rent. Because if you take rent from them, they don't have an estate at sufferance anymore. What do they have?
A periodic.
A periodic, what kind of periodic?
Tenancy.
Month to month tenancy. How long did they just rent that property for? Another month. And I don't care if they paid you $5, $500, or $5,000. They just rented that property for another month legally in this state. So, don't take the rent from them unless you don't want them out. Because now, you got to give them notice all over again. And go through this whole process again. Does that make sense for you guys?
Even if the rent's $1,000 a month, and I go, here's $10, and you,
If they take it, you just negotiated an oral lease for $10 a month. Landlord-tenant law is never very friendly to the landlord. That's the first thing you need to realize. It wasn't meant to be. Because historically, tenants were taken advantage of. So landlord-tenant law is structured to protect the tenant from the landlord. So in that instance, a court's going to probably view that. Probably, I can't say what every court would do. But I'll tell you what the Real Estate Commission says. Don't do it. Because what you open yourself up to is essentially renegotiating that lease now for a new month-to-month lease at $10 a month. That's also why you don't accept partial rent payments. Because a partial rent payment without some sort of a written agreement that you still owe us the money could be construed as a renegotiation of the rental amount. Don't take partial rent. Let them pay it in full. Yes, ma'am.
So, if you had like a drop box where you allow people to pay their rent, if they gave that to you, is that then saying, hey, I'm giving you this, and then
I haven't
that?
accepted it.
So I can take that back to you?
Absolutely.
No, this isn't allowed?
Absolutely. I could take it right back to them, and I would take it back to them with something written, probably certified mail, that says, I am returning your rent. Our agreement was that your lease expired on December 31st. You were given notice on October 15th that your lease was not going to be renewed. You cannot pay rent and remain on the property. You are maintaining the property illegally right now, and we will begin legal action to remove you if you do not. Now, can we sue them for the rent they didn't pay once we take legal action? Yes. Yes, absolutely. But don't take the money while you're trying to get rid of them, because the number one goal is to do what?
Get rid of
Get rid of them, and if you take the money, you're stuck.
Do you have to wait, like, give another 60-day notice?
No, if you took rent, you've got to give notice. Now, we're going to talk about what the minimum notice requirements are, because now we're outside of that written lease. It was the written lease that said we have to give 60 days notice. There is a minimum notice requirement. Thankfully, it's not 60 days, okay? Because now we're operating with a verbal lease. All right? Yes?
You said that don't take partial rent.
Do not take partial rent.
Yeah, but if it's the partial rent has the amount of a written lease, then he find how much the rent is.
Then that's probably okay. That's what I said. Don't take partial rent absent some written agreement that they still owe the remainder. So if you're going to accept a partial rent, you should get them to sign something that says, I recognize my rent is still this amount and I still owe this amount. Because you don't want them to be able to make the argument, oh, hey, we had a discussion and she changed my rent from $1,000 a month to $600 a month. Well, if you got a check for $600 that you deposited, and all of a sudden you got it explained. No, 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 that was partial rent. And you don't want to put yourself in that position.
Yeah.
Okay? You want to have something written where they acknowledge that they still owe.
If it's tax acknowledgement, is that okay?
A text acknowledgement? I'm not going to say yes or no. I would say I probably want them to sign something, but that's just me because I feel more comfortable with that. It's better than nothing. It's much better than nothing. So does everybody understand the difference between a periodic tenancy or a state from period to period, and a state for years, and a state at will, and a state at sufferance? Have we got those? The states at will and sufferance, what's not being paid? Rent. No rent being paid. The difference between the two is the state at will is with what? Permission. And the state of sufferance is without permission. Yes, ma'am.
Why would you do it in a state of will?
Why would you do it in a state at will? Maybe you've got an old home that needs a lot of work. Okay? We're going to talk in this chapter about a lot of the laws that protect residential tenants. You don't get to negotiate in a residential tenancy in this state what condition the property's in. If you collect rent, whether that's $1, $1,000, or $10,000, you have to have that property in fit and habitable condition. If that property is not in fit and habitable condition, you have two options. Fix it or don't charge rent. And I mean none. Zero. So, why might you do in a state at will? Maybe you've got somebody there that's willing to do the work in exchange for paying no rent. You might do in a state at will. Now, you can't they do the work in exchange for reduced rent. Because if they pay rent, you're responsible for everything. Does that make sense? That's an example of why you might want to do an estate at will. The key thing to an estate at will is it has no notice, no expiration, because it's at will. Either party can walk away from it at any time. You cannot hold either party responsible for that agreement. Everybody got that? Okay? Good. It's a lot like a license in that regard. Okay? Everybody good on those? All right. Now, on page 239, they introduce you to the different ways lease payments can be made. What we just talked about is the major structure of leases, how they're structured. Whether it's an estate for years or whether it's a periodic tenancy, is its structure. These things refer to how the money is going to be paid. Okay? What the rent is based on. The most popular lease, because it's the one that happens in residential real estate, is the fixed lease or gross lease. What does the word gross mean? Before you subtract what? Expenses, taxes, maintenance, any kind of expenses. In other words, another way of saying that is, does the tenant care how much it costs to maintain the property in a gross lease? No. I don't care, because who's paying for it? The landlord. In a gross lease, does it matter to the tenant if the taxes go up from one year to the next? No, because who's paying the taxes? The landlord is. What is going to happen month after month with the tenant's lease and a gross lease?
Same.
Nothing. It's going to stay the same. That's a fixed or gross lease, and is that not how most residential leases are structured? If the air conditioning goes out and it costs $2,000, you don't care because that's who's to take care of? The landlords. The landlords. That's a fixed or gross lease. By far the most common in a residential setting. As a matter of fact, it's the only one you can have in North Carolina in a residential setting. The percentage lease is done in retail. What is retail? What's going on? What kind of business are they doing? They're selling stuff, right? So what do you think this lease is based on? A percentage of what? Sales. That's exactly right. They usually have some sort of a flat base for their rent, and then they pay a percentage of their sales on top of that. So let's talk about why they do that. There are several reasons why retail leases are structured this way. Number one, from the tenant's perspective, doesn't the tenant want the shopping center to be nice looking, to be decorated for the holidays, to be welcoming, you know? And so the best way to make sure the shopping center does what they're supposed to do is make it so the more money I make, the more money they make. So that gives them an incentive to go out and hang all the decorations for the holidays and have Santa Claus down there for all the kids to come and jump all over, and the Easter Bunny and all that stuff they do at the mall. Because that's not the tenants that are paying for that, that's the mall who's paying for that. And they're not doing it out of the kindness of their heart, they're doing it because it draws people there. And people do what? Spend money. And there's some percentage of every dollar that gets spent in Crabtree Valley Mall goes back to the landlord. So from that perspective, the tenants want the landlord to be sort of in the same boat with them. They want them to be participating in generating that income. Does that make sense for everybody? The other factor that's at play here is that the tenants want to be able to spread out their rent liability when they have the most money in their pocket. When can the tenant afford to pay more rent if you're a retail tenant? What month? November, December. What month can you not afford to pay anything if you're in retail? January. Y'all do know that all those returns count as negative sales, right? I used to be a very large retail manager. I had 800 full-time employees. And on the day after Christmas, we would actually run negative sales numbers in that store because we had so many returns that we were returning it faster than we were selling it out the front door. Our net sales for the day were negative numbers. You don't want to be paying a big rent number in that month, right? So if your rent was the same every month, January would kill you. When can you afford to pay a big rent number? December. So when you make your rent a percentage of your sales, essentially what you're admitting as the tenant is, I don't have very good cash flow management, so let me pay you when I got it and let me not pay you when I don't. That's the reason retail leases are structured that way. Make sense for you guys?
Yes, sir.
Good, good. So you're going to see that in a retail setting. Now, the other ones you need to be familiar with, over on page 239 is a net lease. A net lease is the exact opposite of a gross lease. What did we say the big component of a gross lease was? That the tenant pays the same amount of rent every month, no matter what the expenses are with the property, right? So whose money fluctuates month to month in a gross lease?
Landlord.
The landlord's money fluctuates. The landlord really doesn't know how much money they're going to have month to month because they can't always anticipate what the maintenance and expenses are going to be month to month. Does that make sense for you guys? Flip that dynamic around and do the exact opposite and you've got a net lease. Now the landlord's money is completely consistent, but whose money might change month to month? The tenant. And why would the tenant's potential expenses change month to month? Because they're now responsible for what? Maintenance. What else? Insurance. What else? Property taxes. And in fact, most of the time when we refer to a net lease, we call it a triple net lease because those are the three triple killers that come along in a triple net lease. Your lease amount is some amount plus what they call TICAM. I want you to write that down in your notes. TICAM, TICAM. Taxes, insurance, and common area maintenance. That's what that stands for. And while your lease may specify what your lease payment is, and that amount may be locked in year to year, guess what can change year to year? That TICAM amount can change. So, whose income is now stable? The landlord's. Do you see why that's a very advantageous and desirable setting for a landlord in a commercial setting? Almost all commercial leases that aren't retail or percentage leases are net leases or triple net leases. Now there's one other type of lease that you will encounter in the commercial world that you ought to be familiar with that they make mention of on the next page, which is a full service lease. What do you think a full service lease includes? What does full service normally mean?
Everything.
Everything. That's what a full service lease includes. When you go rent a hotel room, what kind of lease do you have on that property? Full service, right? They don't send you a separate bill for the electric and the water for that night that you were there, or the TV or telephone. That's all rolled into that one expense. You can rent commercial space in that way. But it's usually one type of commercial space, office space. Office space is very often full service. And the reason for that is usually office space is divided into lots of small little spaces, and it becomes very hard to meter the electric separately, to meter the water, because you don't have a bathroom in every suite, you have community bathrooms, right? So how could you possibly say how this person used this much water and that person used this much electricity, and it becomes impossible. So most office buildings use full service leases where the lease amount the tenant pays is all inclusive of everything, including the utilities. And usually janitorial as well. Okay? So what kind of space is that going to be? Office space. Full service is going to be office. Percentage is going to be what? Retail. Net is going to be pretty much anything commercial other than those two, right? And triple net means the same thing. Gross is going to be what? Residential. Residential. Has everybody got those? Now remember, that doesn't impact whether it's an estate for years or a periodic tenancy. That just impacts how the rent itself is structured, right? You could have a gross lease that's an estate for years. You can have a gross lease that's a periodic tenancy. One is the way the termination of the lease works. The other is the way the money works. Everybody good on that distinction?
Yes, sir.
Good. Good. All right. So now, skip over to the North Carolina Residential Rental Agreements Act on page 244. Okay? Which is, yes.
All of these items, we don't really need to focus structure without touching on it?
Yes, absolutely. That's a good question Robin just asked. She said, all that other stuff you skip over in the book.
That's a great question.
You know what I would do if I were you?
I need so much notes today on all the other stuff.
Because
I thought,
in my experience, those are not asked about on the exam. In my experience, those are not the ones that they're testing you on. They're testing you on the ones I've talked about. Okay? All right. Now, the North Carolina Residential Rental Agreements Act. I'm going to ask what I hope is a fairly obvious question of you guys. What kind of properties are subject to the North Carolina Residential Rental Agreements Act? Residential properties, absolutely. This is not a law for commercial rentals. This is a law for residential rentals. And this is where you get into the stickiness of landlord and tenant law. Because this is where all the rules are. This is where all the protections are for that tenant. This is where you will get yourself in trouble if you don't know the law. Okay? So, one of the first things we say about the Residential Rental Agreements Act is that the obligations of the landlord and the tenant are mutually dependent. fancy way of saying that if one doesn't do what they're supposed to do, the other is not responsible for what they're supposed to do for the remainder of the lease, okay? You're essentially releasing one party from responsibility by not living up to your bargain. But here's what I don't want you to misconstrue that as. A tenant in North Carolina does not have the right to withhold rent. Ever. That, I don't care if they haven't fixed your heat. If you are maintaining possession of that property, you owe them the rent. So what I mean when I say that if they don't live up to their end of the bargain, you don't have to live up to yours, what can you do?
Walk away.
Walk away.
Construction eviction.
Move out. Yes. The constructive eviction. We're going to talk about what that terminology means. But don't think you can withhold rent, because you can't. The Residential Rental Agreements Act is very specific about that. The tenant, as long as they're in possession of the property, must pay rent. Okay, has everybody got that? You don't have that option. Now, the landlord's duties are important, and they're on page 245 in your book. The first one you need to know is this implied warranty of habitability. What the state says is that a residential landlord must supply a fit and habitable premise to the tenant. And your book says that means the premise must be fit for human occupancy, and that the general statute sets forth that standard. It says the landlord must do whatever is necessary to put and keep the premises in a fit and habitable condition. Must do what? Whatever is necessary. So, let me ask you a question. If you inherit your grandparents' house that was built in 1905, and it doesn't have a permanent heat source in it because your grandparents used space heaters to heat it, can you lease that property out in the state of North Carolina? Absolutely not. Somebody said, I can't lease it for full price. You can't lease it for any price. Because it is your responsibility as soon as you collect rent on that property to put it in a fit and habitable condition. And guess what? One of the things they say you gotta have is heat. So shockingly enough,
What
you
about air
have to have
conditioning?
heat.
What about air conditioning?
You don't have to have air conditioning. That is not a requirement. One of the interesting things, though, about requirements under leases is, though, if they bargain for air conditioning, you do have to have it. And you do have to keep it in working condition. So what would it mean to say that they bargained for air conditioning?
It had it.
If it had it when they leased the property, do you have to maintain it? Yes. Landlords get themselves screwed up on this kind of stuff all the time. Refrigerator. They leave the refrigerator in there. Person leases the property. 2 months later, the refrigerator breaks. And the landlord says, well, I didn't have to give you a refrigerator anyway. Well, guess what? You do now. Because when you leased it and you included it, you made yourself responsible for its maintenance. So what would be the smarter thing to do if you were the landlord?
Take it out.
Take it out. In fact, if you want to take it out and put it in the driveway and say, listen, somebody threw away a refrigerator. I hear it works and you're welcome to it if you want to have it. That might be a better way to approach that situation, because then it's clear that the refrigerator belongs to who? The tenant. And if it breaks, it's on them. But if you leave it in there, and especially if you market it and say it includes refrigerator, washer, dryer, guess who's maintaining the refrigerator, washer, dryer?
You are.
You are, because they bargained for it. Okay?
Even if it's a TV, right?
I'm sorry?
Even if there's a TV, right?
Anything that you've included in the lease, which is essentially anything that's in the property when you convey the property, you got to maintain. You've got to maintain. Unless you want to pay a lawyer to specifically exempt certain things, you know, and obviously you could sign a lease and say, we understand that the television is not part of the lease and I'm not expected to maintain it, but you need a lawyer to do that. You need an attorney to do that for you. Okay? So, this implied warranty of habitability means they will keep the property in a safe condition, current with all building codes and all housing codes. How many people own old houses that have been living in them for 50 years that are not current with all building and housing codes? Are they supposed to lease that house out in North Carolina? No, they are not. I didn't say these laws were followed, I said they were law. And these apply not just to us, but they apply to everybody. This is a North Carolina general statute. This is not an agency law or agency rule. This is a general statute rule. Okay? That means it applies to everybody. It says a 2009 amendment of the Act added the requirement that the landlord remediate any imminently dangerous condition within a reasonable period of time, which is dependent on the nature of the problem. I love how succinct that language is, don't you, Sarah? And that doesn't leave any room for discussion. What is a reasonable time and what's an imminently dangerous condition? It did define the following as imminently dangerous conditions: unsafe wiring, flooring or steps, ceilings or doors or windows on ground level, ceilings or roofs, chimneys or flues, lack of potable water, lack of operable doors on all outside doors or windows on the ground level, lack of operable heating facilities capable of heating it to 65 degrees when it is 20 degrees outside. That is specific, right? It has to be. Now, it doesn't say it has to be cheap. You can rent it out if it's got those electric baseboard heaters that cost them $23,000 a month to operate. That's okay. But as long as it's got a permanent heat source in there that will heat it up. And some of these houses, honestly, you couldn't heat them to 65 degrees if you set them on fire. They would not reach that temperature. So, you know, it's not going to work. But they lease them anyway. It has to have, I do like that they did this, lack of operable toilet. I had a tenant call me one time when I was doing property management, which I don't do anymore because I regained my sanity. And she said, I have a plumbing emergency. It was Christmas Day. And I said, Lori, what's the emergency? We can't flush the toilet. And let me give you a little backstory. This house is in Northridge, 6,000 square feet. How many toilets do you think there are in there? There are 5 of them. And I said, you cannot flush the toilet or the toilets, plural. The downstairs powder room, the toilet won't flush. I said, use the upstairs powder room. I know. Actually, what I asked her, because I was smart enough not to walk myself into it, I said, do you have anybody in the family who has any sort of a mobility disability? And she said, no, everybody's fine. Why? I said, then you don't have a plumbing emergency. You have a plumbing inconvenience, which will be remedied sometime other than Christmas Day. And I'm sorry, it's not fun that you have a toilet that won't flush on Christmas Day, but I'm not getting some plumber out there today to remedy that. Y'all understand that's not a plumbing emergency, right? Thankfully, the state has defined that for me. So as long as they have an operable toilet, you're in good shape. All right? So they do try to narrow this down. Now, they also say that operable smoke and carbon monoxide detectors must be installed and maintained, and they must repair those within 15 days of receiving notice of necessary repairs. But the tenant should replace the batteries. That's not part of necessary repairs. The batteries are on the tenant. Yes, ma'am. Sabrina's question is, carbon monoxide detectors need to be low to the ground. Correct. And the answer is, to be effective, yes. You can let them know. She said, should she let her apartment complex know that having them up high is not effective? You are more than welcome to let them know that. There is no requirement that they place them in an effective place. There is simply a requirement to have them. Yeah. And a specific carbon monoxide detector should be lower than the bed level. And the reason for that is carbon monoxide is heavier than air, it sinks, and so your room fills up with carbon monoxide from the floor up. The dumbest invention in the history of the world, and it's only invented because it fulfills a part of the law, is the combination smoke detector carbon monoxide detector. I call this the pick your death tool. Because you are picking if you want to suffocate to death or burn to death. This is what you are choosing when you buy one of these devices, and it tells you that as soon as you open the package. Because it says, this is a combination alarm device. For maximum protection from smoke inhalation, please place on the ceiling of the protected area. For maximum protection from carbon monoxide ingestion, please place no higher than 18 inches from the floor. Because smoke does what? Rises and carbon monoxide falls. Don't buy a combination unit. Buy separate ones. And yes, they should be located, carbon monoxide should be theoretically plugged into the wall.
They get bad.
And they do go bad, they need to be changed, but the ones on the ceiling are not very good because you'll be dead before it goes off. That will be the alarm to come let them know to get you and take you away. So it is helpful, it's just not helpful to you. And that's the best way to think of that. I would get one if I were you and plug it in, lower than that. Okay?
Well, luckily we're upstairs, so.
There you go. So the lower units will get theirs first. You just have to be able, you can hear their alarm. Make sure you can hear their alarm. All right, good. So the landlord has this duty to maintain a fit and habitable condition, and that's non-negotiable. That's the important thing to remember here. They cannot negotiate that away. They can't just sort of throw their hands up at it and say, listen, you're not renting a perfect property. Because the truth of the matter is, if they're leasing a residential property, it should be pretty much what?
Perfect.
Perfect. That's what the state of North Carolina says about residential properties. They just don't give you the ability to negotiate. Yes, ma'am.
So the renter can sue even with an oral contract?
The renter can sue even with an oral lease, absolutely, because we enforce oral leases in North Carolina. And if it's a residential lease and they can prove they're paying rent and they can prove that the landlord is not maintaining the premises in a fit and habitable condition, they absolutely have a claim against that landlord. They do. At the bottom of page 245, it talks about what Keith mentioned, constructive eviction. Constructive eviction is evicting yourself. When would a tenant evict themselves? When the landlord's not doing what? Maintaining the property. The landlord is not maintaining the property, and the tenant has given the landlord ample opportunity to correct the issue. The tenant has the option of simply moving out. Now, what do they not have the option of doing?
Not paying rent.
Not paying rent, but once they move out, then they stop paying rent.
Yes.
Yes, absolutely. So essentially, it's permission to break your lease. That's what constructive eviction is. You can constructively evict yourself if your landlord is not maintaining the property. Now on page 246, we talk about the law of negligence. The law of negligence basically says any reasonable risk the landlord should try to mitigate. So in Sabrina's case, the landlords ought to know that carbon monoxide detectors don't work very well on the ceiling, and so they should probably move them lower. I'll give you a more recent example that really happened here in Wake County. Down by Wake Tech, there's an apartment complex in Garner, and they had 3 young ladies who were sexually assaulted in the parking lot of that apartment complex in a 3-month period. The third one sued the owner of the apartment complex. And the owner of the apartment complex, they actually were sued by all 3 of them. It was only the third one who was successful in her suit. Even though she was represented by the same attorneys, they filed suit together, represented by the same attorneys, it was only the third one who won her suit. Because what the court found was that the landlord had no reasonable expectation that this would happen on their facility for event number 1. And event number 2 happened so quickly after event number 1, 3 days to be exact, that they hadn't had a reasonable amount of time to respond to it. But event number 3 happened a month later. They had never sent out a letter to the tenants letting them know that these 2 events had happened. They had not arranged with the Wake County Sheriff's Department to increase patrols in the neighborhood. They had basically just done nothing to prevent a future attack. And the court said, in case of plaintiff number 3, she has a legitimate claim against these people because they were negligent in trying to prevent that. Does that make sense for you guys? That pretty much sums up the law of negligence. If a tornado comes through and knocks a tree down on top of a house that I own, I'm probably not going to be liable for somebody that gets hurt in there. But does it change the equation if the tree's been dead for 3 years?
Yes.
Absolutely. If the tree's clearly dead and I hadn't had leaves on it in 3 years, I I should have understood as the landlord that that was a risk and it needed to be taken down. Does that make sense for you guys? That's the law of negligence. That in essence, if you have reason to expect a risk, you should fix it as a landlord. Okay? Over on, and that's the law of negligence. Over on page 247, we talk about how we evict residential tenants. How residential tenants are evicted in the state of North Carolina. Every state has a different process for this. It's a different set of rules in every state, and you've got to know the rules in your state to make sure you follow them, because the quickest way to get yourself in trouble is something called self-help eviction. It sounds like something you go take a class on, right? You know, like self-help. No. Self-help eviction means illegal eviction. You're not allowed to evict a tenant in any way other than summary ejectment. That's the magic phrase. In North Carolina, you must use the summary ejectment procedure in order to evict a tenant. It doesn't matter what the tenant did wrong. It doesn't matter for how long they've been doing it wrong. You don't get to choose the eviction method. It's already been chosen for you by a court of law. Does everybody follow that? What do we call it when you do something other than summary ejectment? Illegal, and what's the legal terminology for that? Self-help eviction. That's the court terminology for it. So I'll give you some examples of self-help eviction. A shotgun. That is a self-help eviction. You show up with a shotgun, you tell them to get out. That is not allowed in the state of North Carolina. I don't care what they did that prompted you to do that. Changing the locks on the doors is a method of self-help eviction. While it may be effective, it is not legal. You cannot do it. Taking doors off the hinges. I even heard somebody say they took the toilets out of the house. No, don't do that. Do not do that. As a matter of fact, while we're having this discussion, does a landlord have the right to enter a property without advance notice to the tenant? No. The only reason they should ever enter property without advance notice to the tenant is if there is some imminent danger in the property. It's on fire, they hear water running out the doors somewhere, something is going on that they have to get in right then. That's the only time they have the right to enter that property. If they enter it without notifying the tenant first, any other time it's called breaking and entering. It's a crime. Yes.
What about subsidized housing?
Or about subsidized
Do
housing?
they have the right to enter?
No. Same thing.
They have to notify them first.
You have to give they have the right to enter, but not without notice. That's right. If they come and spray for roaches, they need to give you a note. They need to give you a note. And the tenant has the opportunity to say, no, that's not going to work. Now, the tenant doesn't have the opportunity to continue to block access. If that becomes excessive, the tenant has exceeded their rights. But the landlord must give notice to enter the property.
Travis,
Okay?
on that same point, if you signed in your leasing contract that you will participate in those periodic inspections or things like that, is that considered notice?
No.
Okay.
They still have to give notice. They still have to give notice. And it's a good thing that they mention it in the lease to make it clear, but they still have to give notice. One of the things I always did when I was a property manager, the best way to sort of keep an eye on the condition of properties was changing the filters in the HVAC system. We would have regularly scheduled intervals, and we'd go out and put notice on the doors and say, we're coming back tomorrow between this time and this time to change your filters. And of course, while we were in there, we would make notes about anything that looked out of kilter in the property. But we did give them notes that we were going in. Okay? Can't change the locks. You must bring an eviction action or a summary ejectment action in court in front of a magistrate. These are heard in front of magistrates in North Carolina, usually not judges. The magistrate's going to make a decision here. Now, if you're going to get into property management, there's a way to do this, and I'm not going to get into it here because it's not tested. There's a way to do this and a way not to do this. Let's just put it this way. Your number one goal when you go for a summary ejectment is not to get money. Your number one goal is to get what?
Property.
Get them out. If you start suing them for money, you're going to complicate the process, and it's going to take even longer to get them out. And I'll give you just a short idea of why. In the state of North Carolina, if I sue you for money, they must effect personal service on you before you're expected to appear in court. They will dodge that personal service for a very long time. Whereas if I am simply suing them for possession of the property, don't have to have personal service. It can be left on their front door. You see how that might be advantageous if my number one goal is to get them out of the property? Because if you make a claim, I want them out and they owe me money, now we got to get personal service. They have to be served personally for those documents. So you want to go through the process, but there's better ways than others to work the process. You can get an expedited eviction in the event of criminal activity, but you still have to go through the summary ejectment process. You might get a faster treatment, maybe. That's not guaranteed either. But you certainly cannot self-help evict. You still must go through that summary ejectment process. Okay? What are the tenant's duties? Well, keep your premises, the property clean and safe. That's one of their duties. Obviously, they cannot destroy the property. They cannot create hazards in the property. They have a duty to maintain a safe condition around that property. And then what do you think their biggest duty is other than that?
Pay rent.
Pay the rent. Absolutely. Pay the rent. Keep it clean. Don't destroy the property. Comply with regulations. Be responsible for damage. Tell the landlord when stuff needs to be fixed. And most of all, pay your rent. That is a tenant's statutory duty. All right, we're going to talk about constructive eviction and what it means. Retaliatory eviction. This is something they like to test you on sometimes in the exam. Retaliatory eviction. This is basically taking action against the tenant because the tenant has tried to hold you responsible for what you're legally responsible for. You need to fix my heat. You need to get out of my house. That's retaliatory eviction. It's illegal. You can't do it. The landlord doesn't get to say, well look, I don't like you, you don't like me, you got to get out. No. They have to fix the heat. It doesn't work that way. The tenant has bargained for a certain lease time and they're entitled to it. And as a landlord, you must understand that. So you shouldn't rent out a property unless you're ready to maintain that property. No matter, even if you're spending more than you're taking in. So that's something to always keep in mind. Okay? Landlords don't have to renew leases at all. We do honor leases after the sale. When properties are sold, the lease is an appurtenance to the property. The lease goes with the property. That means the tenants go with the property. That means the new owner has to do what? Honor the lease. This includes when the new owner is a bank. When might the new owner be a bank? In a foreclosure. I am thankful sometimes for regulation. This is one of those cases where I am thankful for regulation. I will tell you, having gone through the market collapse in 2007, 2008, 2009, that one of the ugliest realities of that was tenants who were paying their rent, current on their rent, having a sheriff show up at their door and say, you got 10 days to get out. Because that's what the law used to be in this state if your property was foreclosed on. There was no protection for them. And so now, what the law says is that the bank is not treated any differently than any other landlord who buys a property. When they take over this property in foreclosure, they take the tenants over with it. And they must honor any written leases that exist on that property. If that tenant has a written lease, they must honor. Now, that doesn't mean they have to allow, well, they have to allow. That doesn't mean they have to be landlords. What they generally will do will find some kind of a mutual agreement whereby the tenant agrees to move out of the property. What are some ways you might talk a tenant into moving out?
Paying them money.
Give them some money.
Get another place.
Give them some money, help them get another place. We will refund your security deposit right now. Which, by the way, is that probably going to be a loss for the bank?
No.
Because who's probably got the security deposit?
The person who did own it.
The person who did own it, and they ain't paid a mortgage, they're gone, you ain't going to get it back from them. The bank's probably going to refund that security deposit out of their own funds. And they're probably gonna give them some free rent for some period of time. They might even write them a check and say, please be out by Friday and we'll pay you this much money. Because they don't want to be a landlord, because if they're a landlord, what are they responsible for? All that maintenance on the property. And they don't know what they just inherited, so they don't want to do that. But they are responsible for that lease. If somebody wants to honor that lease, now of course this is created, when you create a well-intentioned law, you always have people that take advantage of it. Now you have people who, when they get foreclosed, they lease it to their cousin for the next 2 years at $100 a month.
And in the book, it says you can't do that.
Says you can't. It's very hard to prove it. I mean, again, where would you prove that? In a court of law, right? You know? And it gets very expensive and yeah, you're right. You're not supposed to be able to do it, but I'm telling you they do. They do, and then it's up to the banks to go and prove it, and it's just becomes a mess. It's well-intentioned, but it gets taken advantage of. Okay?
What was that again? I'm sorry.
You don't need to know it. Not on the test. Not on the test. You don't need to know it. It was just an aside story. Okay? All right. We already talked about self-help eviction not being allowed. You must use the court system. The Tenant Security Deposit Act on page 248. This is another law that you need to be well aware of in North Carolina. Now notice it doesn't say the Residential Tenant Security Deposit Act, does it? So we've now moved out of rules that are specific to residential property, and we are in rules that apply to what? All property. The Tenant Security Deposit Act applies to all property. Let me tell you why we have a Tenant Security Deposit Act. When the fair housing laws were first passed, they were primarily passed to prevent discrimination, not in the selling of real estate, but in the leasing of real estate. Does that make sense for everybody? Quickly, certain owners figured out that they could accomplish the same thing by manipulating the amounts of security deposits. Oh, absolutely, we'll rent the property to you. The security deposit is $25,000. So, as a follow-up to the fair housing laws, several years later, almost every state passed a law like this one, including this state, and we call it the Tenant Security Deposit Act. And it governs what a security deposit can be used for and how much of a security deposit you can charge legally in this state. So look at that chart there, or those 3 bullet points on page 248. It ties the maximum amount of the security deposit to the length of the lease. How long does it say, or how much does it say you can charge if you are on a week-to-week lease?
2 weeks.
2 weeks. How about a month-to-month lease? A month and a half, and anything longer than month-to-month is 2 months. So what is the maximum allowable security deposit in the state of North Carolina?
2 months.
2 months rent. No matter how long the lease is for, 2 months rent is the maximum allowable charge. Okay? Now, we also say that there are certain things that are allowed and certain things that are not allowed to be charged against a security deposit. Before I talk about the things that are allowed, let me talk about when they are allowed. More specifically, let me talk about when they're not allowed. If that tenant is still in the property, folks, you can't touch that security deposit. All these things that we're going to look at on this next slide, where it says it's okay for you to charge this against a security deposit, it's not okay for you to charge it against a security deposit while the tenant is still in the property. The tenant security deposit, while the tenant is in the property, is going to stay where?
Trust.
In a trust account. And by the way, that rule doesn't just apply to real estate brokers. It applies to everybody. If you lease a property in this state and you hold a security deposit, where must it be held?
Trust account.
In a trust account, and you must know the trust account rules and you must follow them. If you hold, how many of you know somebody, you can be honest, who is violating the Tenant Security Deposit Act right now? Almost all of us do. And they probably don't even know they're violating it. Here's the danger to them. If they get a tenant who's smart, and eventually they will, tenant's gonna move out, and gonna owe them money. And they're gonna try to charge it against that security deposit. And the tenant's gonna walk down to the courthouse and they're gonna file a suit, suing them for that security deposit. And when they show up to court, they're gonna say, Your Honor, yeah, I took the security deposit, he didn't pay me rent the last 2 months he was there. And the tenant's gonna say, and what trust account did you hold my security deposit in? Where is your trust account located? And when the answer is, well, it was in my checking account, what do you think is gonna happen to that security deposit? It's gonna get refunded back to the tenant because it was improperly held. Does everybody follow that? That's the danger of not holding it in the correct place, okay? So, these are the allowable uses of a security deposit after the tenant has vacated the property. Non-payment of rent, that's the obvious one. They owe you rent, you can charge that against the security deposit. Damage to the premises. Now, when we talk about damages, we are not talking about wear and tear. We're talking about actual damage. Now, in your book, over on page 249, it differentiates what the difference is between damage and wear and tear. Basically, the way I look at it is this: if it can be cleaned, it's not damage. If it cannot be cleaned and has to be fixed, it's damage in most cases. Even still, there are some things there that still are not allowed. Notice it says ordinary wear and tear would include frayed curtain and broken blind strings. It doesn't say why the blind strings are broken, maybe the dog chewed them up. It just says wear and tear includes the blinds. So you can't charge a tenant for blinds. That's what it boils down to. You cannot charge a security deposit. You can charge a tenant, send them a bill and hope they pay you, but you can't charge against a security deposit. Did everybody follow that? You can't charge them for the little holes that used to hang their pictures on the wall. You can charge them for the big ones that they hung their TV with. So there's a differentiation between what is damage and what is ordinary wear and tear. Unpaid bills that could become a lien against the property. These are usually utility bills. Like a water bill or a sewer bill can become a lien against the property. You can charge the security deposit for that. Cost of removing their junk that they leave, but they always leave presents. And court costs. Any of those are allowable to be charged against the security deposit, but only when? After they've moved out. And you've got a time limit. You have a certain amount of time. How long is it? 30 days. You got 30 days to give them a breakdown of what happened to their security deposit. Yes, ma'am.
What if the damage that they've done to the property is more than the security deposit? So then you would just write a bill to them. But, I mean, most people that have done something like that, they're not gonna pay that bill. So is there any way to enforce that besides taking them to court and you having to pay for it? Like, there's liens on property.
How do you enforce anybody owing you money?
I just didn't know
I think you know the answer to your own question, you just don't like the answer.
No, she said it would hit them on their credit and it would go to collection. That's kind of what I was asking.
And that's pretty much it, right? You have to hope that they care enough about their credit, they probably don't, that that's going to matter, right? So taking them to court's about the only option. And at some point you got to know when to cut your losses, because taking them to court could just cost you more court costs, and you get a fancy judgment on a fancy piece of paper that's worth nothing because they ain't going to pay you still. I got lots of fancy pieces of paper that ain't worth any money. Yes, ma'am. Net deposit, okay? So a debt deposit, I'm relatively unfamiliar with. What I'm more familiar with is a pet fee. They do a pet deposit. If they do a pet deposit, then they should clearly outline what that pet deposit is refundable for or not refundable for, because it's not covered under the Security Deposit Act. Okay? So they better have something at least that's going to outline what they can.
Well, they do have to have the pet deposit and then each month you pay a $20 extra.
But does it outline what the pet deposit can be used for? Right, it should clearly outline.
Like 20 days a month.
Yeah. Because otherwise there's not gonna be any guidance on that. Okay, is everybody clear on the maximum allowable security deposits, when you can touch the security deposit, where it must be held? Are we good on all that? Good, good.
Wait a minute, I'm sorry. Yeah,
Yep.
I'm good.
Sure? Sure, okay. Alright, so we can charge for damage to the premises, but not for ordinary wear and tear. Obviously, you do not want to participate in any sort of harassment at all. That comes up in this section because the most likely time you're going to get claims of sexual harassment are in leasing of property. Leases are always more prone to all kinds of complaints, and so they bring it up in here. Now, public housing tenants, which is on page 250, or subsidized housing tenants, do get certain additional rights. They don't get less rights, they get more rights under the law. Specifically, you cannot evict them for the most common reason that you would evict ordinary tenants. What is the most common reason you evict an ordinary tenant?
Non-payment.
Non-payment of rent. It is specifically prohibited to evict a subsidized housing tenant due to non-payment of rent. Okay? You are not allowed to do that.
Government's paying most of the bill.
And that's the reason why, Monty, you're exactly right. Because the vast majority of the rent is not being paid by the tenant, but by whom?
Government.
But by the government, exactly. There's some subsidy coming in that's covering the vast majority of the rent, yes.
So even if they break their responsibility and lose that subsidy, you still can't?
If they lose the subsidy, you can certainly evict them. And actually, it won't be you that has to evict them at that point in time. If they lose the subsidy, they'll get kicked out of the program, and that's permission. The lease you sign with them gives you permission as soon as they're out of the program that the lease would be terminated. So, yeah, if they lose the subsidy, and they can lose the subsidy, that's what will happen if they stop paying the rent. Eventually, they'll lose the subsidy through the Section 8 program, right? And so that absolutely does happen. But you, as a landlord, don't have the opportunity to go to court and file for summary rejection for non-payment of the portion of the rent that that tenant is paying. So if you're going to accept Section 8 vouchers, which you're not required to do as a landlord, if you're going to accept them, you should understand that and basically be willing to accept the portion that's coming from the government as rent and hope you get the other portion.
But you can non-renew in that circumstance, correct?
You cannot renew, absolutely, but you cannot evict for that reason. You can simply choose not to renew.
I thought you had the other reason.
No, because you can stop participating in the program. Now, you can't say, I'm not renewing this particular tenant, but I want to continue to participate in the program. You can simply, at the end of that lease, say, I'm no longer going to accept Section 8 vouchers. Okay? Yes, sir.
Can that be for specific properties? I've got 3 rental houses.
Yes,
So one of them I can say no more, but the other 2 can.
absolutely. It's a property by property basis. It is a property by property basis. What they generally don't let you do is go in and out of the program though. Once you've been in and you say you're no longer accepting the vouchers, generally speaking, they won't let you back in with that property. They may let you with another property, but not that specific property. Okay? Now, the last thing in this chapter is the Vacation Rental Act. Here's the way to think of the Vacation Rental Act. I'm going to throw these up here and blank it out for just a second. People get confused about the Vacation Rental Act because they don't understand why we have it. We just talked about a lot of rules, right? And who do all those rules protect? The tenant, right? There's pretty much nothing we just talked about that was good for the landlord. Everything about it was, the tenant gets this, the tenant gets that, the tenant gets this. If we didn't have a Vacation Rental Agreements Act, when you go to the beach and you rent a house for a week, if you wouldn't leave, what process would they have to use to get you out? Summary ejectment. It takes 45 days. That would be kind of tough in a vacation rental setting. Does that make sense? So the entire purpose of the Vacation Rental Agreements Act is to avoid all of those responsibilities that come under the North Carolina Residential Rental Agreements Act. What we're saying is, yes, these properties look residential, but they're not subject to the residential rules because they are vacation rentals. Does that make sense for you guys? Now, in order to get this special treatment, you can't lease the property for more than 90 days at a time. So how many of you have ever stayed at like an extended stay place and noticed that when you sign their little agreement, it's for a maximum of 90 days? Well, this is the reason, because if they leased it to you for more than 90 days, like a furnished apartment or something like that, then they're subject to the Residential Rental Agreements Act. Does that make sense for you guys? So it'll always be 90 days or less when you rent these properties. The biggest things here is it allows for expedited eviction. Pretty much all that stuff that I said you couldn't do to evict the tenant in a residential setting, you can do to evict the tenant. Yes, you can show up with a shotgun in some counties. I'm not going to tell you to do it, but I'm going to tell you that the sheriff is probably not going to frown on you all that much if you do. You can certainly show up with big, strong people and throw people out because they don't have any right to be there after their time is expired because all those protections are waived. Okay? Now, to get this treatment, the property has to only be used for vacation rental purposes. Okay? You're not allowed to sort of switch it back and forth and pick and choose. You know, it's got to be a vacation rental property. All right? And the people that are renting it must have a home somewhere else. They must prove to you when they check in that they do have a residence somewhere else. The idea being, if we're going to give you the right to give an expedited eviction, they need somewhere else to go. Does that make sense for you guys? So the only reason this exists is to give you expedited eviction in vacation properties. Yes, ma'am.
Let's say you have a couple of vacations in the area, can you, while you have people staying there for a week, can you pop by? Or is that considered like?
While you have people staying there for you, can you pop by?
Well,
Pop by to do what?
Check on them.
You, I mean,
Check
grilling
on
out with them, or what are you doing?
Checking to see like if they're having a bunch of parties at your house or something. I mean.
Well, I mean, I would say you have the right to monitor the property in the same way with notice that any other such establishment would. So if you gave appropriate notice, yeah, you could knock on the door, but there's going to be a judgment call about when that becomes excessive.
Could be maid service.
Could be.
Back to the security deposit, I have a question. As far as the 30 days, as far as...
We're talking about a residential security deposit?
Yes,
Okay.
as far as receiving the summary of 30 days, I get that, but how long do they have as far as returning the security deposit?
30 days.
30 days, so, okay.
That's what the 30 days is. When we say account for the security deposit, we mean account for it with the rest of the money. If there's money owed, that has to come back in 30 days. The only exception to that rule, and you won't be tested on this, so you can tune it out if you want to. The only exception to that 30-day rule is if it takes you for some reason longer than 30 days to obtain the charges. Like, for example, maybe they screwed up the flooring and it's taking you a long time to get quotes on how long it's going to cost to fix the flooring. That you can get an additional 30 days in that case, but it's rare. Basically, within 30 days, you need to account for what money you've taken and refund the rest. And if you don't send the accounting within 30 days, you're not entitled to any of it.
That was my question.
Yep.
So there is some statutory provision for the tenant. He doesn't have to go to court.
No.
Okay.
I mean, if they don't give it back to them, they're going to still have to go to court to get it because, I mean, how do you force them to give it back? But they are entitled to it back.
Okay.
Okay? Everybody good on that? Good on the Vacation Rental Act?